Can I use my opponent's trial exhibit to cross-examine his own witnesses? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is yes, I can. So now, let's say this is a medical malpractice trial, and I'm about ready to get up to cross-examine the defense's medical expert, the doctor whom they have brought in to claim that their doctor did absolutely nothing wrong. So here's the scenario. The doctor, this medical expert, is now on the witness stand. The defense attorney is questioning him. He's taking a few hours to question him and take him through step by step to show to the jury that their client, the doctor whom we have sued, did absolutely nothing wrong. And during the course of that questioning, the defense lawyer is using various exhibits to show to the jury that their doctor did absolutely nothing wrong. The defense lawyer got a couple of those medical records enlarged. We call them blow-ups or enlargements. They are 30-inch by 40-inch pieces of paper that are now glued onto this foam backing. It looks like poster board. So now that's marked for identification. And why does he do that? Because this way the jury can follow along. He puts that on an easel in front of the jury, and now they're reading along as the doctor is following along on the papers that he has in front of him. So now, after a while, he's finished with his questioning, known as direct examination. And then it's my turn. The judge turns to me and says, Mr. Oginski, you can begin your cross-examination. Great. So now I start my cross-examination, and during the course of questioning this medical expert, I now want to use that big poster board, that big enlargement that I know has cost a lot of money to make. So now can I go over to the defense lawyer's easel, take it off his easel, and now walk in front of the jury with this big exhibit? The answer is yes, I can, especially if the document upon which this is based is already in evidence. Now, what does that mean? So the doctor, the medical expert who is testifying, can testify only about records he reviewed if those records have already been admitted into evidence. So either I or the defense lawyer will have gotten those records into evidence before the doctor gets up to testify. This way, now when the doctor says, yes, I reviewed the following records, they are already in evidence. So now at the end of the trial, the jury will be allowed to see them while they are deliberating. But now here's an interesting question. Are those big exhibits, those 30-inch by 40-inch poster boards, are they also in evidence? The majority of time they are not. They are simply enlargements to help the jury follow along while we are questioning a particular witness. So the question I raised in this video is, can I use my opponent's exhibit to go ahead during the course of questioning of his own witness? And the answer is yes. I can go over to his easel, pull out that big poster board, hold it up in front of the jury to try and show that this witness is being less than truthful, to highlight certain things in that particular record. Now, it does get a little bit interesting when our exhibit is based upon electronic evidence that we've got stored on our laptop, and now we need a projector to display for the jury. It's a lot harder to turn to my opponent and say, hey, can you turn on your projector, turn on your laptop, and go to page 327 in this medical record, because I want the jury to see what this doctor did. It's a bit harder to get my opponent to go ahead and agree to that. But where he's already had that exhibit, he's questioned the witness with it. Now I have every right to go over and use that exhibit to show to the jury. How awkward would it be if I go to reach for that trial exhibit and now the defense lawyer turns to me and says, hey, Oginski, you can't touch my exhibit. I spent all that money to do it. That's mine. You can't touch it. You can't use it. That would be really awkward. Then I'd simply turn to the judge and say, Judge, he used this exhibit to go ahead and question his witness. I want to use the same exact exhibit to cross-examine him. The judge in all likelihood would say, go ahead, Mr. Oginski, take the exhibit. You can go ahead and use that. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what goes on in real life and a real trial here in the state of New York in a medical malpractice case. You know, I do understand that you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit but have not done so yet because you still have questions that need to be answered, then what I invite you to do is pick up the phone and call me. You know, I answer questions just like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.